we are pleased to be hosting attorney Kirsten Howe. Kirsten is the founder and managing attorney of Absolute Trust Counsel, a Walnut Creek law firm dedicated exclusively to providing comprehensive, client-centered estate planning services. For over 25 years, Kirsten and her team have provided counsel on estate planning, trust, and probate administration, Medi-Cal planning, special needs planning, and other related matters. An expert in her field and noted speaker, Kirsten also hosts Absolute Trust Talk, which is an informative podcast and a Facebook Live series with the purpose of educating the public on important estate planning and elder law topics. Actually, this podcast is fabulous. I've seen it, and I was one of her guests as well, so I encourage everyone to go and find it under Absolute Trust Talk. She has experts from the community come and talk about issues, just like we host here, issues relevant to seniors. Kirsten earned her law degree cum laude from UC Hastings College of Law, where she was managing editor of the Hastings Law Journal. Originally from Chicago, Kirsten earned her undergraduate degree from the University of Michigan, and she is a member of the Trust and Estates section of California State Bar and Estate Planning, Probate and Elder Law sections of Contra Costa County Bar. She is also a member and former director of the Estate Planning Council of Diablo Valley. So this lecture today is also sponsored by our Rossmore Fund, an organization that helps residents in financial stress. So thank you all for coming, and I'm very glad to welcome Kirsten Howe today.
Thank you. Thank you, Penny. That was a very lovely introduction, almost as if I'd written it myself. I'm really happy to be here. I've been to Rossmore many times. I have clients in Rossmore. I've come to visit them. I see some familiar faces in this room, in fact. A couple of things. The real title is Documents Everyone 55 and Up Should Have Completed. So we're going to cover the basic estate planning documents that we all need. And then I'm going to also go into a lot more detail talking about trusts. And I have I think I have 10 points of things that people need to think about when they're planning their trusts and oftentimes don't. So what we're going to cover, the documents that everyone needs to have, the Advanced Health Care Directive, the General Durable Power of Attorney, a will or a will and trust, and then we're going to talk about the 10 crucial questions when planning your trust. So we'll go into the most detail on the trust because that tends to be the thing that matters a lot, although I would argue against that. Okay, so the first document I mentioned, Advanced Health Care Directive. How many people in the room here have an Advanced Health Care Directive? Okay, that's very good. It should be 100%. Everybody over the age of 18 needs an Advanced Health Care Directive. If something happens to you, in this document, you are saying, this other person who I trust and who knows what I want can make decisions for me, medical decisions. And you never know when that might be necessary. You could get in a car accident, you could have a stroke, you could have dementia. It could be something that happens gradually. So everybody needs to designate a healthcare agent. That person's primary responsibility is to make medical decisions for you. They basically take your place when interacting with doctors and hospitals. They can sign consent forms. The doctor can come to them and say, well, you know, there's 3 things we could do. We could treat this with medication, we could do surgery, or we could wait and see and do nothing. Who's going to make that decision? You want to choose the person who will make that decision for you. This person is also able to make placement decisions for you. So if you're in a situation where you need to go from a hospital to a skilled nursing facility and you can make a choice, this person is legally enabled to make that choice for you. Same with assisted living. You know, they can make placement decisions. They also, if you choose, can be responsible for your remains if you die. And in your healthcare directive, you can say whether or not you want to be an organ donor. Ultimately, this person will then have to agree to donating your organs. You can also put other wishes in your healthcare directive, but they're just that, they're wishes. Those kinds of things are not legally binding, but I think it's important to explore that as much as you can and communicate as much as you can with the person you've named so they know what you would agree to and wouldn't agree to. Having the actual conversation is the best. You know, if you've named one of your children or all of your children as your healthcare agent, sitting down and just having a conversation. But putting it in writing is also good. So that's where we would do that, is in your healthcare directive. Okay, the next critical document is the General Durable Power of Attorney. And this, again, is a document that applies on incapacity. And I'm going to say, I'm just going to point out that most people, when they think of estate planning, they are thinking about planning for what happens when they die. And that is estate planning. And historically, that was it. That's all we did. We did wills and we did trusts. But in the last 50, 60 years or so, as more and more of us live a really long time because of all the medical advances we have, estate planners have also become very concerned about incapacity. So we do these powers of attorney, we do these healthcare directives. And I think that getting the incapacity part in place correctly is perhaps more important to you than getting the after-death stuff right. Because after your death, you know, it's not your problem anymore. If it takes a long time to get things done, if your kids are having a hard time accessing your bank accounts and they have to fight with Wells Fargo, you know, it's just time. But if you're incapacitated and your kids are having to fight with Wells Fargo to get access to your money, you need that money. You need them to be able to act for you quickly. And so these documents, the incapacity documents, I think need to really be well prepared and kept up to date, maybe even more so than the after-death kinds of documents. So I'm just going to put that out there. Now, the General Durable Power of Attorney is a document where you, again, you name somebody else who you are giving legal authority to act for you. And you're giving them authority to act, we call it a general power of attorney, so we're giving them very broad powers in most cases. We want them to be able to do anything you might need them to do, any legal or financial thing. So it could be something like you've become incapacitated and we need to pull money out of an IRA because there are bills to pay. We need to pull money out of an IRA. This person has the legal authority to do that for you. Remember, your IRAs are not in your trust. Maybe you don't remember that, but I'm reminding you now. So things like that, it could be something big and financial. It could be something very small. You know, you're incapacitated and maybe now you don't need all the different streaming services that you subscribe to, right? You got Hulu, you got Netflix, you got Amazon. You don't need that right now, and you need someone who can call up or cancel those subscriptions, and they're in your name. That's an account that's in your name. You need someone who can do that. So the general power of attorney applies to financial assets, and I should be on the next screen because it applies to non-financial accounts, like utilities, like streaming services. Any kind of thing that only you can do because something is in your name, this person can do for you. And we want them to have very broad powers because we don't want anything slipping through the cracks. Does anybody have a guess as to what happens if we don't have those broad powers and we need them? We have to go to court. We call that a conservatorship. So if you're incapacitated and you have not dealt with this aspect, you have not designated somebody who has legal authority to do things for you, your family will have to go to court and do a conservatorship in order to get that legal power. And conservatorships, even in the best of circumstances, are not pretty. They're very expensive. They take a lot of legal time, hence they're expensive, and they are ongoing, and every couple of years you've got to go back to court and report back to the judge. Very expensive. You don't want that, and they take a long time. So with a power of attorney, your person, I'm going to say your child, this is just assuming most people name a child. Your child can step in right away with the power of attorney. They don't have to go to a judge. They don't have to serve notice on the whole family and wait 8 weeks or 12 weeks for a hearing date. They have this document they can get going right away. So I have a personal bias. I think taking a look at incapacity in your estate plan is very important, and really focusing on that and getting it right. One other thing I would say, so what we do, what lawyers do for you, is we write a general, durable power of attorney. So like I said, we're trying to cover everything. We're trying to make sure somebody in your family or in your circle has the power we need them to have. That doesn't mean that it's going to go smoothly. So banks in particular, various financial institutions, and I'm not going to name any of them, probably all of them, they can be very picky about the documents that they will honor. So if you are incapacitated, your child goes into your bank with your power of attorney, the bank is legally required to accept it as long as it's executed correctly, but they don't always. They will push back. I have had many, many clients have trouble with a financial institution. And so, you know, we can usually resolve it by, my client calls me and we say, okay, just give me the phone number and I'll talk to somebody. But that's time and that's legal fees that you shouldn't have to pay. We can usually resolve it. What I am telling all my clients nowadays is even if you have an estate plan and you have a general power of attorney that your attorney created for you, it's a good idea to go to your financial institutions and do their power of attorney. All the big institutions, they have their own form of power of attorney, and you just go and you fill it out, and that way, if the time ever comes that somebody needs to step in and manage things for you, they cannot reject the power of attorney because it's their form. You know, clearly you did it right, they cannot reject it. That's just kind of a belts and suspenders approach, which is what I tend to like to do. We don't want to leave any cracks at all in your estate plan, and I think this is a really good one. Next time you're in your bank, just ask them, do you have a power of attorney form? And you can take it home. You can even ask your attorney to help you fill it out. But that's my little kind of inside baseball tip for you. Okay, so now we're moving away from the incapacity, and the other one or two really necessary documents in every good solid estate plan. You either need a will or you need a will and a trust. Now, the vast majority of people in California, and I'm going to guess in this room, need a trust. Just a will is not going to get you where you want to go. And the reason for that is if you have a will, your estate is going to go through what we call probate. And I'm imagining that most people in this room are familiar with that word. It's a little bit of a dirty word in my business. We are always trying to avoid probate. So probate is a court process. So if you own, let's say you have a bank account with $200,000 in it, and you die. Now we have this problem. There's a dead person who owns a bank account. And the only way we can fix that problem is with this California probate procedure. It's a court procedure. There's a judge involved. There's going to be attorneys involved. And therefore, it takes a long time. It's public. All of the probate records are just right there in Martinez for anybody to look at. And it's very expensive. It tends to be very expensive because the attorney who's doing the probate gets a percentage, okay? So, we, in my law firm, we love to do probates. We love to make money. But when we're setting up an estate plan for our own clients, we don't want that to happen to them. We do probates for other people who didn't plan ahead. We're happy to do it because we make a lot of money. And I don't want any of you to have to do that. So there's two ways to get out of that. When you die, if your estate is worth less than $184,500, that's everything added up together. Your home, your bank accounts, your investment accounts, your cars, your couches and all that kind of stuff. If it's all less than $184,500, we don't have to do a probate. There's another little workaround. It's private. We don't have to go to court. But most people, that number isn't high enough to cover everything, right? If you own real estate in California, really, almost anywhere in California, that number is just not high enough. So the way we get away from doing a probate is by creating a trust. So not a will. A will still has to go to probate. But a trust helps us get out of probate. So, and how it works, how many people have trusts in here? All right. I really love that. You're so far ahead of the average in California. That's great. With a trust, it says what you want to happen when you die. That is true. But it also is a place to put your assets. Your trust, while you're alive, will own some of your assets. So it will own your house. It will own some of your bank accounts. It will own some of your investment accounts. It actually owns the assets. So when you die, we don't have that problem, that terrible problem of there's a dead person who owns property. You don't own your property. Your trust owns your property. So we avoid that problem. We don't need a judge. We don't need to do a probate. So in California, we use trusts because this is the rule. and our probate process is, frankly, terrible. It's not, it's not consumer friendly. It's not what anybody wants to do. And I will say probably 9 times out of 10 when I'm meeting with a new client for the very first time, they say something like, well, we know we're supposed to do this because we don't want to do a probate. People know that, and it has that reputation. It's not something that you deliberately choose. Okay, the other nice thing about a trust is that your trust owns your property, so if you become incapacitated, the person you name as your successor trustee can very easily step in and get control of your property. They don't have to use that power of attorney. It's a lot easier with a trust than with a power of attorney. We don't get banks and financial institutions pushing back on trustees. We get that problem with the power of attorney. Okay, so now those are the critical documents. That's a solid estate plan, and those of you who have estate plans, you probably know this already. You got to have a health care directive, you got to have a power of attorney, You got to have a will or a will and a trust. Now we're going to focus in on the trust, and I'm going to talk to you about a few critical questions that I think need to be considered when you're trying to plan what should my trust say. And for those of you who already have a trust, this is good for you to listen to, because you might hear something that makes you say, oh, maybe I should update my trust. And that happens a lot. We do a lot of updates in my law firm because life changes. Things change, and you want it to be lined up and solid. Make it easy for your family. Okay, so the number one thing to think about, well, what if I become incapacitated? Of course, I made that number one. I already told you I have a bias about worrying about incapacity. Something that people don't always think about. If you become incapacitated and you are, every month, you are sending one of your children $200, or you have an elderly parent and you're helping pay their rent, or whatever it is, if there's somebody who is financially dependent upon you, and then you become incapacitated and your trust doesn't say anything about that person, your trustee, when they take over, they are not going to be able to continue that plan that you had in place. That you were supporting somebody, you were paying your child's cell phone bill, whatever it is, it needs to be considered, and if it's important to you, it needs to actually get into your documents so that your trustee can continue that, if that's what you want. And a really big one that happens a lot, and this is very unfortunate, a lot of times, especially older people, our age, mature people, they have a significant person in their lives, but they don't want to get married. And there's lots of reasons not to get married after the first time. I get that. And so they may have a home that is owned by one person, and the other person lives there because, they're sweethearts and they want to be together. But if you become incapacitated and your trustee has to take over, and it doesn't say anywhere in that document, oh, it's okay if my boyfriend continues living in my home, the trustee can't allow that. The trustee's going to have to either get him out of there or charge him rent. And that might not be what you want. So this is one that happens a lot. People have to think about who's financially, entangled with me. And living in your home is a financial entanglement if they are not also on the title to your home. Another one that we see a lot, we have a lot of clients who have their home and then they also have a rental property or multiple rental properties. That's not very unusual. And they may have a child who's living in one of their rental properties, and maybe they're paying rent, maybe they're not. Maybe the rent they're paying is not fair market rent. The parents, this is very common, parents give their child some kind of sweetheart deal on the rent. Then if the parent becomes incapacitated and the next trustee takes over, if we haven't said anything about it's okay to continue this sweetheart deal if I'm incapacitated, if the trust doesn't say that, the new trustee actually has to do the right thing, which is to make that property productive, to make it charging fair market rent. There's nothing wrong with a parent giving their own child a deal, but you got to be really clear. If that's what you want to continue, you need to talk about that in your trust. And I'm sure as you're sitting here, you can imagine other examples of something like that, where people tend to, help each other out in whatever way. And if it's important enough to you that it continue, you need to talk to your lawyer about it and make sure that's documented for your family. Otherwise, there's going to be, when people disagree, when things happen and somebody sees it one way, somebody sees it the other way, the end result oftentimes is litigation, and we definitely don't want that. Okay, so also thinking about if you become incapacitated, who should be your trustee? Now we're just focused on the trustee. You know, you're going to have a successor trustee in two circumstances. One is if you become incapacitated, the other is after you die. And they're two different jobs. So the trustee who takes over while you're incapacitated, their job is to spend this money, take care of the assets for you. They have to be aware of what you need and what they need to write checks for, and how the assets need to be invested to give you your best life, because you're still alive, you just happen to be incapacitated. After you die, the person who's your trustee, their job is pretty straightforward. They just have to settle out the estate and make sure the money goes where it's supposed to go. You aren't there waiting for them to take care of you after you've died. It's a different job. So it's not unusual to have two different people named as successor trustee. I want this one if I'm incapacitated. After my death, this other one. So one thing to think about is if someone's actually having to take care of you, spend your money, figure out what you need, maybe they need to be somebody who lives a little nearby. So we have children who live all over the country. I'm guessing some of you do. I do. I've got one living in Columbus, Ohio right now. Probably wouldn't be a good choice for trustee for me while I'm incapacitated. So my other son, who lives a half a mile from me, is the one I have named for my incapacity trustee. He's actually also my death trustee, because he would be better at that too. But it's just something to think about. And the other thing, being a trustee, especially, well, always, being a trustee is a lot of work. It's a big job. When you're incapacitated, it's a big job, and you kind of need to be available. You need to be able to react. You need to be able to get involved and get things done. So just think about, you know, am I naming someone who actually has the time to do this, who has the bandwidth? If you're naming a child who, she has her own career, she has 3 kids, they're all going to soccer practice and ice skating lessons, and she's like in the car all the time, maybe that's not a good choice. Maybe she doesn't have the time to do that. So just think about that. These things that I'm telling you, I'm not telling you anything is right or wrong. I just want you to think about things. Okay, so now we're talking about who will be my trustee on death. As I said, that's a different job. My trustee when I'm incapacitated is a different job. When I'm dead, there's usually less urgency. Nobody's taking care of me anymore. They're just taking care of my money and following my instructions. So we have a lot of trustees after death who live elsewhere. They might live on the East Coast, and it works just fine. You know, we have Zoom, we have email, we have telephone, we have everything you could possibly need to make remote work doable, and we have discovered that in the last few years. It's definitely doable. So a remote trustee after death is probably just fine. It is very important, again, that you pick someone who is responsible and will actually get the job done. We can't have, you know, procrastination. We can't have dilly-dallying. We've got to have someone who's going to roll up their sleeves and get to work, get the job done. Of course, they have to be trustworthy. That's why we call them the trustee. So I like to, whenever there's an opening in a conversation with a client, I like to make a suggestion that they consider using a professional as their trustee. It's not right for everyone. There are families where there's only one child, we're leaving everything to that one child. That would be easy enough for the child to be the trustee and get it done. But a professional trustee can be advantageous in a lot of situations. So, if you have multiple children, and in most families I meet with, they think their children get along just fine. And I'm sure they do, but you don't really know, you never will know as a parent what's happening when you're not in the room, and especially what happens after you're gone. And a lot of times the parents are what kind of hold the family together and hold everybody in their proper positions. It's just something to think about. So there are people in California, we call them licensed professional fiduciaries. They do this for a living. This is their business. They have been trained. They've taken a test to become a professional fiduciary. They have background checks, fingerprints. They're bonded. All of this through the state of California. It's an official license that they get from the state of California, and they have to do continuing education to maintain their license, and they are allowed to be the trustee for people who aren't related to them. That's their business. They are neutral, so if there's any danger that your children won't get along, having a neutral person might be a good thing. The other thing about the professionals I have found, so we don't serve as trustees for people. We serve as the lawyer for the trustee. So if somebody dies, now their trustee needs a lawyer to help them figure out what they're supposed to do. We do that. We don't serve as trustees. But I do serve as the lawyer for some licensed professional fiduciaries, because when they're serving as a trustee, they also need a lawyer to help them figure out what they're supposed to do. But what I will say is when my client is a professional fiduciary, I hardly ever see them, because they know exactly what they're doing. They call me up when they need my help, but most of the time they are off doing the trustee's job. They don't need my help because they know what they're doing. It's what they do for a living. My family member trustees, when I'm the attorney for a family member trustee, we spend a lot of time with our clients because they don't know what they're doing. We have to educate them. We have to make sure they don't make mistakes. We have to fix their mistakes. There are much larger legal fees when we have a family member trustee. I'm going to put that out there because whenever I suggest, well, maybe you should think about a professional fiduciary, a lot of clients will say, oh, but that costs money. It does cost money. It does. But it can save your family from the kinds of epic battles that result in everybody having Thanksgiving in their own home, and it actually, it might be just about the same in terms of cost when you factor in the fact that the professional fiduciary doesn't need a lot of help from the lawyer. So again, I'm not advocating, I just want you to think about it. That can be a really good option. What I would say, when you're trying to figure out who should be the trustee after you die and you have multiple children, I would just love it if you would talk to those children before you finalize anything. Just say, Mom and I are thinking we're going to name oldest daughter as the trustee. How does everybody feel about that? Get there, take the temperature before you do anything. My advice to you. Okay. All right, so thinking about what the trust actually should say in terms of who gets what. We have to think about as with incapacity, we have to think about who all might need your help. So, the standard estate plan is we leave everything to our kids. If you have children, leave everything to our kids. But there might be other people in your life who could also benefit. And that doesn't mean you have to leave them money necessarily. So you might have elderly parents. If you died before your elderly parents, maybe it would be nice for there to be a little pot of money that can be used to help them if they should ever need money. And it can say, this money is here for my mom and dad. If they need it, we can spend it. But if we don't spend it all, after my mom and dad die, it's going to go to my kids. So you can sort of set money aside, but not let go of it. Another real common thing that people like to cover is people who have grandchildren. They worry about their grandchildren. It's expensive. Life is expensive. It's expensive to put a grandchild, to put any child through school, not to mention college. So a lot of grandparents like the idea of setting aside a little bit of money to help pay for education. And you can do that. You can really say whatever you want. In your trust, you can say, I'm putting $100,000. This is just for my grandchildren's education. It's not for my kids. My kids are getting this other money over here. This is just to take care of my grandchildren. You can do that. So I'm just suggesting, think expansively about who you would like to help out and how. Okay, so when this is now kind of down to the bare bones of planning a trust, who's getting what. You've got to think about, it might be appropriate for some people or some entities to get a specific dollar amount. I want to give $10,000 to ARF, because you're an animal lover. It might be appropriate to give a specific asset to somebody. So you could say, I'm leaving my vacation home to my oldest child. We call those specific gifts. That's one way to do it, but in the end, we've got to give away everything, right? This trust eventually has to give away 100%. So at the bottom, you're going to have some way of allocating the rest. We call that the residue. That's the official legal term. So you can have something that's a combination of specific gifts and percentages, so that in the end, the percentage adds up to 100. We've gotten rid of everything. And you can benefit individuals, don't have to be family members, and you can benefit charities. And charities are nice if you're charitably inclined, and also nice if you're worried about taxes. So, because charities don't pay taxes, so that's something to think about. Okay, so the question that we probably ask the most when we're having a planning session with a client starts out with, what if? So the client will say something and we go, great, that's a great idea. We start writing it down. What if? And we've got to explore all the what ifs. So one of the main ones we always have to cover, what if a beneficiary dies before you? Okay, so I leave my vacation home to my oldest daughter. Well, what if she dies before you? Where's that vacation home going to go? Does it go to her children? Does it go back into the pot? Or does it go to one of the other children? You've always got to ask that what if. What if the beneficiary dies before me? What if the beneficiary is immature or irresponsible or a minor, has a substance problem? We have to talk about those things. It's not pleasant, but we have to make a plan for that. You can leave money to someone who's irresponsible. You can leave someone money even if they have a substance problem, but you want to control it. And so you need to talk to your attorney about those things. I'm kind of worried about this one person. I know I want to leave them money. They need the money. But if I leave them all this money, it's going to ruin them. And I don't want that. There are ways to deal with that. So you've got to ask that what if question. And now this one is one that's very important in my practice. What if the beneficiary is receiving government benefits? So we do special needs planning, meaning we do estate planning for usually parents, sometimes grandparents, who have a disabled child or grandchild. And they want to leave money to that disabled child, but they don't want to ruin the government benefits that the child is receiving because of their disability. They might be on Medi-Cal, or they might be getting some other kind of benefit that if they suddenly had a $50,000 inheritance, the benefit would go away. There are government benefits that are really very important to disabled people. You can leave their inheritance to them in a special needs trust. It doesn't have to be, here you go, here's a check, it's yours. And that would really not do anybody any good. So, you know, thinking about your family, are there people in your family who possibly could someday be in that situation? In my practice, every trust that we write has a special needs just in case provision. Because we don't know. You know, right now, everybody in the family is healthy, but 10 years from now, we might have a grandchild who actually is receiving some kind of government benefit. We want to make sure the trust can handle that. We want to make sure the trust will not ruin that for the grandchild. And if you know there's a special needs person, then you definitely need to address it. This next one is maybe the most, I don't know, popular or common discussion we have. What if my child or whomever I'm leaving money to is married to someone you don't like? That happens a lot. And it isn't always that I don't like that guy. It's more like I just don't know. You know, I'm worried. He seems kind of domineering. I'm afraid if I leave all this money to my daughter, he's going to persuade her to do something. You know, oh, let's open a restaurant, honey. That's a good idea. That's a good business plan. So we get that, I would say, most from parents of daughters. They tend to worry about that son-in-law. So we can set something up to make sure that the money is there for the daughter and only the daughter. Son-in-law doesn't get any of it, and then when the daughter's done with it, it goes to grandchildren. So that is possible. It's becoming more and more common, and just something for you to think about. Think about who in your life, maybe you're not leaving them any money, but what if? If you leave that money to your daughter and then she dies, where's it going to go? It's going to go to her husband, unless you have written something else, unless you are controlling it. So I'm just suggesting that you open your mind and think about all the what ifs in your life. Okay, so this is a really important question. What assets will your trust own? And related to it is, does your trust in fact own these assets? So as you're sitting here, a big percentage of you have trusts already, and I'm hoping that you are all 100% confident that your trust has title to everything it's supposed to have. We have, in my office right now, probably 5 or 6 probates that we are doing where the deceased person had a trust, and we're still doing a probate. And that's because they set up their trust, everything's great, it's a perfectly fine trust, but they left some of their assets outside of their trust. And so then, when they die, what is the problem that we have? We have a dead person who owns property. So even though there's a trust, we're going to go do a probate. And that is like my least favorite conversation to have with a client. Oh, I see that you and your attorney set up this trust. your mom set up this trust, but guess what? We still have to do a probate for your family. So, your trust should own your real estate. All of your real estate, even if it's, you know, in Arkansas. I don't care where it is. If it's in the United States, your trust should own it. We can't own foreign real estate. You got to do that with a foreign attorney. But all of your real estate, your trust should own it. Your trust should own most of your bank accounts. Most people don't put their checking account in their trust, and that's okay, as long as you keep in mind that number that I told you about back many slides ago, 184,500. We don't want to go over that number. That's when we have to do a probate. Your investment accounts, your trust should own that. If you have a business or an interest in someone else's business, you know, you're just a silent partner, you have a limited partnership interest somewhere, all of that needs to be owned by your trust. And if you're not 100% confident that that's true, I'm going to strongly encourage you to just make an appointment with your attorney and say, I just want to go over the funding and making sure everything is really nailed down, because it really is just, it's sad. It breaks my heart when I have to do a probate for someone who went to all the trouble of setting up a trust. So we don't want to do that. And what I will also say is some assets, we like to see them coming into the trust after death. And maybe you can imagine what some of those assets might be. Life insurance, for example. You could have a life insurance policy that you own yourself, and you can make your trust be the beneficiary of that life insurance policy, which is kind of a nice thing to do. That's usually the best choice. So either your trust is going to own it during lifetime, or it will own it after death. The one exception I would say to that are retirement assets. We don't generally like IRAs, 401ks, 403b, whatever you have. Those are not meant to go into your trust while you are alive, and we have to consider carefully whether we want them to go in after your death. So that's a conversation you have to have, is very specific to your situation. Okay, a really important question that I see from time to time, it's obvious that this question was never asked, is will it work? So here's an example. The client has 3 sons, and she's got this house, you know, here in Contra Costa County. It's worth $1.5 million, something like that. I don't know. And she writes an estate plan. She wrote an estate plan 20 years ago. And the estate plan said, I leave everything equally to my 3 sons, which is fine. 20 years ago, that would have worked just fine. But over the course of the 20 years, one of the sons moved back in with mom because he doesn't have a job. He's really not employable, so he's kind of completely dependent on mom, and he has no place to live, and he has no money with which to purchase a place to live. And mom, in her old age, has spent all of her other money. So by the time mom dies, really all we have is a house. And her trust says, I leave everything equally to my 3 sons, one of whom needs that house. You know, so maybe if mom had known that that's how it was going to play out, she would have written something different. Maybe she would have wanted that house to go to the son, or she would have said, you're all going to own the house, but he gets to live there. You know, there are things we could have done. That turned very ugly because the other 2 sons wanted the dependent child to get out, and they ended up hiring attorneys to do, you know, an eviction of their brother. So thinking about, will it work? You know, equally to my 3 sons, that's nice. That's nice. But sometimes equal isn't what's best for everybody. Sometimes something different is more equitable. And the example I just gave you, maybe something that favored that other son a little bit would have been better for the family, because right now they are, completely blown apart. There is no family anymore. Another thing that we see problems with is Prop 19. You all familiar with Prop 19? Everybody loves it, right? Prop 19 is the law that came into effect last year, and it had two sides to it. The one side is great, everybody loves it. We can take our low property taxes and move to any other county in California and have the same low property taxes under certain circumstances. Everybody loves that, that's great. The other side of Prop 19 is you don't get to pass your real estate down to your children with that low property tax, except in a really, really specific situation. Used to be you could pass all of your real estate within broad limits. You could pass all of your real estate on your death to your children, and they would pay the same property tax you were paying, even though you bought that property in 1978. Now, we can't do that anymore. Thanks to Prop 19, we can only pass our personal residence, and only if a child turns it into their personal residence. So if our children inherit our personal residence and they want to turn it into a rental property, the property taxes will go up. And, some of my clients had, they didn't have a lot of IRAs, they didn't have a lot of 401ks, they had a lot of rental properties. That was their retirement plan, and it was a good plan. Now they have these rental properties that they would like to leave to their children, but when the children inherit the rental properties, the taxes are going to be so high that they really won't be profitable anymore. It's really hard to make that work. So just understanding that if you have real estate, whether it's your personal residence or some commercial property or some rental property that you've got, and there's any kind of, it's kind of important to me that my kids be able to own that property, you need to talk to your lawyer. Find out what can we do to make that happen if the property taxes are an important issue. The other thing is there enough cash? So my prior example, when I was talking about the 3 sons where one was living in the house and that was all there was no cash. So that's an example of that. How, even if it wasn't a problem that the son needed to live in the house, even if they all agreed, we're going to sell this house, there's no cash on hand right now to do the things that need to be done. So, sometimes you want to think about that. How are your investments allocated? You might want to make sure that there's going to be a little bit of cash in the trust in order to do the work of the trustee. So an example of this that I just had not too long ago was talking to some clients about, well, we have this checking account and the savings account, and they're never going to be over $184,000. So why do we need to put them in the trust? Well, you don't if you only worry about avoiding probate. But if you don't put one of those accounts in your trust will have no cash. And then you die, and how is the trustee going to hire a lawyer? How is the trustee going to pay the accountant to do the tax returns? You want to at least think about, do we need to figure out a way to make sure there's cash available to pay for things? Okay, number 9. Married couples, how many trusts? This is an important consideration, especially for married couples who are on their second marriage or third or fourth. It's getting, then it gets really important. So I have a number of clients who, remarried kind of later in life, and husband had his property when they got married, and wife had her property when they got married, and then, they bought a house together, and they're living in the house. And so sometimes for those people, it makes sense for them to have 3 trusts. They're not just going to have one trust and smush everything together. Husband has his separate trust, wife has her separate trust, and then they have a joint trust. And that's not at all unusual because they each have a different idea. They have their own children. They have a different idea about what they want to happen after they die, and they might have different investment strategies. This is an important point in the case that I just finished working on. The wife wasn't comfortable with the husband's level of risk tolerance. So she didn't want to have all of her assets invested in a way that made him happy. So she kept her assets in her own separate trust. She's the only trustee. She gets to make all the decisions. She doesn't have to worry about, I don't want to be 70% in stocks. I'm good with 50. She wanted to control that. So sometimes we have multiple trusts for a married couple. And that's often true also when one spouse has inherited a lot of wealth from their family, and they want to keep that wealth within their family. They don't necessarily want it going to their new spouse when they die. So it's kind of important to them to keep it separate. So we do that not infrequently. Now, one other important point for the married couples in this room, beyond how many trusts should we set up while we're alive is the question, how many trusts should we have after we die? In the old days, a married couple's trust would almost always say, when we die, this trust is going to split into 2 trusts. And we did that because we were worried about estate taxes. Right now, hardly anybody is worried about estate tax. I'd say 99% of my clients don't have to worry about estate tax because the exemption amount per person is over $12 million. So, that is enough for most of us, right? Certainly it's enough for me. So we don't need to do that fancy planning of splitting the trust into 2 trusts in order to avoid paying taxes. You might like it for other reasons, but if you've been married for 40 years to the same person, all your kids are your kids, there's no stepchildren, there's no animosity, there's nothing weird happening in the family, you might not like that complicated of an estate plan. You might like a more simple estate plan that doesn't require the surviving spouse to split everything into 2 pots. You might, but you might not. I just want you to think about it. If your trust was last updated before 2013, I am encouraging you to take a look at that. Go back to your lawyer and say, do I have an AB trust? That's what we call it when it splits into 2. Above ground and below ground. AB. Do I have that? And the second question is, do I need that? Maybe you do. But I want you to think about it. I want you to decide and not get stuck with it. Because we see that a lot. We have clients, the widow comes in, my husband just died, I have this trust, and this is my second least favorite conversation. I see you have this trust, and guess what? Now we have to make it into 2 trusts, and I'm really sorry because you don't need that. Clients don't like that, So take a look. That's an important one. Okay, and this is the most common question I ever get asked in client meetings and in presentations is how often do we need to update? When do we need to update? There's a lot of reasons you might need to update. Things in your life have changed. you had these beneficiaries and now some of them have died, or you just don't like some of them anymore. Or you have some new people that you want to add in there. So a change in beneficiary, a change in the trustee. You named this person to be your trustee and they're dead, or they're in prison. Who knows? Any reason that you don't like that person as a trustee, or I had a lot, just yesterday I met with some clients who their successor trustee was the husband's older sister, which was fine 20 years ago, but she's 83 years old now. So that's not a good choice, and they want to make a change. Change in assets. Remember, like the example I gave you of the 3 sons and 1 lived in the house and now there's no money? That's a change in asset. It could be change in the other direction. You might have a whole lot more money and maybe more planning needs to be done, or you just need to think about it differently. Change in wealth up or down. Or, you say in your trust, I'm leaving my vacation home to my oldest daughter. What if you sold that vacation home? Would you change your estate plan? Maybe you would. Maybe you wouldn't. Or the vacation home burnt down and now it's just an empty lot. You want to leave that for your oldest daughter? Maybe you want to spread that pain around. I don't know. Just something to think about. Changes in the law. Changes in the law don't usually require that you update your estate plan, but they might give you an opportunity. There might be something that's, that could be better because the law has now changed. And just a little bit ago I said, the law changed, the tax laws changed in 2013, and for married couples, that AB trust thing really isn't necessary to save tax money. That was a law that changed. Those AB trusts are still fine. They're perfectly fine, but it kind of creates a new opportunity for you to think about a different way of doing things. So once in a while, the law changes that kind of opens up an opportunity. It doesn't usually change in a bad way, except Prop 19. That was bad. And I will argue with you if you disagree with me. A change in your health, it might mean that you got to plan a little differently. You're going to be a little more worried about running out of money, and maybe something different needs to happen. That's something just to think about. Okay, so those are the 10 points. I'm just telling you here, I said I'm really biased toward incapacity planning, so there is a page on my website. So my website, absolutetrustcounsel.com, I have a specific page. It just has a whole lot of resources, a whole lot of information about incapacity planning, and you can go directly there. We also have a whole page about trust administration. That's what happens after you die, the job your trustee has to do. We call that trust administration. These are just a couple of things I'm pointing out to you. As Penny said, we do a podcast. You can find all of the episodes on my website. If you ever want to, while you're walking or working out or whatever you do, you want to listen to something, you can listen to our podcast. So we have lots of resources, and I encourage you to check that out. So now I'm taking questions. I'll take questions in the room and I guess out of the room. Yes.
What's reasonable fee for trust administrators, whether it's professional or if you've chosen your own? I would think they would be entitled to some compensation for all these duties they might need to perform.
Okay, yeah, so the question is about the trustee fees. I would, when you ask an attorney a question, they're always going to start by saying it depends. So it depends. But when we have family member trustees, they generally will charge for their time. So we have them track their time, just like a lawyer, has a timesheet. And we tell them, you know, probably somewhere between $50 and $75 an hour is reasonable. There's no hard and fast rule. The banks, so most banks have trust departments, and they can serve as trustees. They will usually charge somewhere about between 1 and 1.5% to do that. So whatever, if the estate is worth $1 million, 1.5% of that, that'd be their fee generally. The professional fiduciaries, they're all different. They might work by the hour, they might charge a percentage. It's never going to be more than the banks would charge. And they're just going to look at the case and figure out what's the best way to charge it, you know. So that's, I'm just kind of giving you some ideas. There's no definitive answer. But ultimately, the beneficiaries have to be okay with the fee. So the trustee doesn't just get to say, oh, I'm worth $300 an hour, I'm going to pay myself $300 an hour. The beneficiaries would probably object to that.
I have a only child, and I have a close-knit of friends that we call the Counsel. I'm wondering if I can have the Counsel work with my daughter as my agent.
You can. When you say agent, do you mean on a healthcare directive or on a power of attorney?
Both.
Both of those things?
Yeah, I think personally, my friends know me better.
Mm-hmm.
However, she's my daughter. I know she'll take care of me, but I think they have great wisdom and input for her. And so I was wondering if there's some way I can word that so that she has somewhere to go, and then she'll make the final decision.
Yeah, you absolutely can do that. For sure, in your healthcare directive, you've got to name one person or a number of people who are the decision makers, you know, because the doctors have to go, okay, who's making the decision? So you could name your daughter as the decision maker, but you could write in there that I want you to talk to these people. These people will help you and will advise you. With the power of attorney for legal and financial matters, it can be a little, you can say the same thing, but a bank or any kind of financial institution is going to want to know who is the person. And we don't care. We don't care if that person talked to this other group of people. So it's really kind of a suggestion.
Okay, but I can put it in writing
yeah.
in my wishes.
I would, if it's important to you, put it in writing. Yes, okay. You can do that.
Okay, and my other question real quickly. I had my trust done, and the attorney that I had that did it, I've never spoken to before. I'm sorry, I've never spoken to again. And I'm not real comfortable with them. I'm sorry I chose that attorney. My question is, can I have another attorney look at my trust and update it and explain to me what we did?
Yeah, so the answer is yes, you can. You aren't stuck with your original attorney. You can walk away from them, and you don't even have to tell them. You just, okay, I'm going to talk to this other attorney and see what they have to say. And we get a lot of new clients that way. So, you know, a lot of estate planners tend to be solos. And so when it's time for them to retire, the law firm goes away. So we get a lot of new clients for that reason too. Yes, you are free to go wherever you want.
I'm going to take a question on Zoom, and then I'll come back over there. What's my question? Okay. What if you fill out an institution's power of attorney form and later fill out or change the general power of attorney connected to you, connected to your other documents, to name someone else as the power of attorney? Then you get dementia. Which power of attorney will the bank accept? How to fix after the fact designation? Okay, so that is such a good question. That is someone who's really thinking like a lawyer. What we say in our general powers of attorney
right in the very top, in the first paragraph, we say, I hereby revoke all prior powers of attorney except any power of attorney that I have completed with a financial institution is on that list. So that's what is the best way to do it. How do you fix it after the fact? I mean, you got to look at the documents and see, do they really conflict with each other? It might be that there's a carve out there for the financial power, the bank's power of attorney. But you got to pay attention to that. Your power of attorney, your general, should allow you specifically to fill out specific powers of attorney.
Thank you.
Thank you for your presentation.
No, you're welcome.
If part of the estate includes an IRA that's been untapped, so no taxes have been paid on the withdrawals, does the status or income level of the beneficiary, does that affect the taxes that'll be put upon the IRA when it's passed on to the next person?
Yes. So the IRA, you have an IRA and you die and you leave your IRA to a child, let's say. That child will be required to empty out that IRA in 10 years. That's the new law. Used to be they had their whole lifetime to empty it out, but now it's 10 years, and they will pay tax on that. Every distribution they take, they'll pay tax on it at their tax rate, which might be lower than yours, might be higher than yours. Yeah.
What's involved in transferring the title of your Rossmore property into the trust, and is Golden Rain going to go along with that, or are they going to charge a transfer fee?
Okay, that is a really good question. So there's two kinds of basically two kinds of situations you could be in here. You might actually own the real estate. Some people in Rossmore actually own real estate, and you can do whatever you want. You can put that in your trust. If what you own is shares in the mutual, then you have to go through Golden Rain, and they will allow you to do that if there's no mortgage. If there's a mortgage, they have a whole other thing that they do. They put, it's complicated, but I'm just telling you, you need to understand, do I have real estate or do I have shares in the mutual? If you have shares in the mutual, just go talk to them. And whether they charge a fee, I think they might. Okay, I've got a question here. But it's worth doing, even if it's a couple $100.
Pertinent to the last question, are you referring to the co-ops?
Yes.
Okay. I have a question concerning the Proposition 19. Does that pertain to a family member? Say you have a non-family member that you would want to leave your home to. Would they get that tax advantage through a will or through the trust?
Okay, so the only people who have the possibility of keeping the same property tax that you have on your death is a spouse or a child. No other family members, no friends.
The next Zoom question is, we had a trust made but can't find any papers. The attorney has retired. Does that trust have any value?
Again, it depends. What I would say is, if that trust owns assets, you know, like if your home, if you go look up the deed to your home and it says the John and Mary Smith Trust is the owner of the home, then that's true, and you've got to figure that out. I've had a few clients who lost their trust, and we were able to track back by looking at their real estate. Oh yeah, this is the name of your trust. This is the date that you created it. And so then we just do a restatement. We write a new document and everything's fine.
Okay, and then final question, can a bank account or IRA list the trust as the beneficiary?
Yes, and that is a good strategy, especially for IRAs, listing your trust as a beneficiary if what you want to do is control what happens to the money. If you leave your IRA to a person, they can do whatever the heck they want with it. If you want to control what they do with your money, then you leave it to your trust. Or if you want the beneficiaries to be minors, then you leave it to your trust, because minors can't own an IRA. They will have to go through a legal guardianship process, and that, that's court. We're trying to stay out of court.
If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcounsel.com/scheduling.